साक्षी सुरेश साळुंखे ma'am will start. Now I would request Dhanashri Kadam ma'am to welcome Archana and Apurva. Now let's proceed to the mood workshop session. I request Saluki ma'am to share her mood techniques.
लाईन्स कुठं भेटतात वर्डमध्ये? त्या लाईन्स कुठं भेटतात वर्डमध्ये डबलवाले? मला तर सिंगलच भेटली, डबलवाले भेटलेच नाही.
Thank you so much for the warm welcome. It is a privilege to be presenting a workshop such as a Moot Court workshop in this institution, and I would like to start with the very basics of a Moot Court workshop. My preferred language would be English and Marathi because I got to know that people are comfortable in both of these languages. So my preferred language would be English and Marathi. You all can just give me a heads up if you think that English and Marathi be okay for you all, or you want me to have a conversation in Hindi as well, then that will also be alright. Thank you. So I think if the screen is visible to you all, this is a Moot Court memorial. Now the practice and procedures that we generally follow in a Moot Court are very different to what actually the high courts or the lower courts, and the way in which they perform and function are different. Now what happens is, when we go to the actual courts, there are 5 basic stages involved in any court that is supposed to be followed pan-India. Okay, so the 5 stages are research, drafting, filing, listing, and then arguments. So these are the 5 stages that any particular advocate who wishes to go about the matter goes through. Now, as compared to that, when we come before presenting something like a matter before the workshop, or like when it comes to a Moot Court workshop, there are 3 basic stages involved. The 3 stages are research, which is the core of any particular moot problem, and there's no straightjacket formula involved in research. The second part is drafting. 3 members for the petitioner or the complainant, who is a member of the particular team, and there are 3 members to the opposition. Now what happens is, when the 3 members are involved, 2 of those members are speakers and there's 1 researcher actually get to do the research of the problem. Y'all as students, when participate in a moot competition, y'all get to understand that y'all first get a moot proposition. Now, the moot proposition is a very basic document which tells you what a moot proposition holds in itself. Now, the factual matrix will be a part of the moot problem, and you will be given a few issues to deal with, based on which you will understand as to how you are going to go about the entire factual matrix. If we move on to the next page, this is the first page of a petitioner's memorial. Generally, the petitioner's memorial is in blue color, only for us to understand that this is a petitioner's memorial. A respondent memorial is always in red color. Just the first page of the memorial is red in color. Now, we move on to the next. This is the table of colors are supposed to be a part of any particular memorial that you are given and you are supposed to work on. Now, there are lists. If we see the first serial number, there are list of abbreviations given. List of abbreviations is basically when we participate in any court, or let's say if we approach before any particular high court, what happens is we need to understand that there is a certain legal language that is supposed to be used before any particular court. Now what happens is, if you see, there are abbreviations such as ANR, or let's say ORS, or let's say VS. These are very basic interpretations of what another means, or what other means, or what versus means, and these are basic things which are supposed to be taken or approached as abbreviations. Now the second part is the index of authorities. What happens is, when we go about a moot proposition and we understand the factual matrix, but the factual matrix is supposed to be interpreted in such a way that the courts have already dealt with it, and such courts, while dealing with it, also have certain legal case laws, wherein such case laws or such precedents have already been set by the higher courts, which the lower courts have to follow. It is binding upon the lower courts. And of course, the high courts or the supreme courts, while dealing with such issues, if they have already dealt with such issues, there will already be precedents in the form of case laws, which will be available on any legal website. Let's say the free websites are Indian Canon, or let's say the subscribed version of it would be SEC Online or Live Law, and you would find all of these case laws over there. Now what happens is, index of authorities is something that is supposed to be curated with as much mental capacity as you all can use. I'll tell you why. If we get onto the index of authorities, what happens is, people generally dump a lot of case laws into the index of authorities. But these index of authorities, or the case laws that you add into the moot memorial, is very much important, because that is which bridges the gap between your moot memorial, that is the factual matrix, and the actual problem at hand. So you can't be dumping anything and everything that goes into moot memorial as compared to the case laws that are supposed to be actually added in. Sometimes what happens is, y'all are already allocated with the number of pages that are supposed to be added in the index of authorities. Now let's say, for example, you are given 2 pages allocated for the index of authorities, and you have something else to add on. Or if there are a few other case laws that are supposed to be referred by all, then there's something called as a compendium. Now the compendium is again a list of additional case laws or additional documents which y'all as oppositions or parties can refer and rely on, and the compendium can be presented before the court on the same day when the proposition or the competition is supposed to take place on. The third part, or the third serial number, let's say, is the statement of jurisdiction. Now, statement of jurisdiction is the deciding factor whether your particular case would be standing before that particular court or not. The statement of jurisdiction. If something goes wrong with the statement of jurisdiction, if we look at the way the High Court performs, everything is based on the statement of jurisdiction in the first place. If the statement of jurisdiction is not interpreted in the right sense, the case gets dismissed then and there. It does not even move forward to the argument stage, or let's say prima facie, it does not move on to the issues part of it. So the statement of jurisdiction can be decided. An example of this would be any case wherein fundamental rights are violated of an individual, we can approach the Honorable Supreme Court directly under Article 32. Now what happens is, if fundamental rights attached with a few sections which have been violated and you need to approach a particular court, then in that case you can approach the High Court of that particular jurisdiction. What happens is, High Courts have powers under Article 226, and an individual can approach the court or the High Court under Article 226, considering the fact that the fundamental rights are violated. Now, there's a problem when it comes to people who participate in moot courts for the very first time. What happens is, people say that articles are infringed or sections are violated. This is not a language that you basically use in a court of law. What happens is, articles are always violated. They can never be infringed. And sections are something which are infringed. So we need to understand the legal language that comes with experience as well. The fourth serial number talks about the statement of facts. Now, the statement of facts are basically given in the moot proposition itself. What happens is, basically, the moot proposition is balanced most of the times from both of the parties when it is given to you. But there are always loopholes involved. Now, what needs to be done is, you will have to go through the moot proposition, that is the factual matrix, again and again, so that you need to understand that there are loopholes into every line that is given to you. Okay? So you all need to understand that if you read the moot proposition with a different mindset on different occasions, you will understand that there is a separate perspective altogether that is given to you all in that case. Now, the statement of facts cannot be altered or it cannot be played with when it comes to adding it into the memorial. The statement of facts is supposed to be same for both the parties. The loopholes or the arguments with regards to it is supposed to be a part of your statement of issues. Now, your statement of issues will be divided into 3 or let's say 4 subheads. What happens is, when the statement of issues are already framed and they are given to you, it becomes easier for the parties to interpret the law in the right sense. But when the statement of issues is not given to you all, and you are supposed to prepare the statement of issues, it becomes a wider scope, because then the interpretation becomes different for both the parties. The complainant, that is the petitioner, or the respondent. So the statement of facts remain the same for both the parties, and those are not supposed to be altered with at any given point in time. The fifth serial number is the statement of issues. Statement of issues, if let's say for example the parties are given with 3 statement of issues, statement of issues can have subheads into the same. So those subheads can again be distributed between 2 speakers. If there are 2 speakers in any particular team, what happens is, either 2 issues can be dealt with by one person and one single issue including prayers can be dealt with the other person, or there can be sub-issues that can be dealt with 2 different speakers at any given point in time. So you need to understand your modus to actually work with the statement of issues. The 6th serial number talks about the summary of arguments. Now, what happens is, when parties are supposed to argue in a memorial, and it is supposed to be referred before the court does not have enough time to make you understand, or maybe you don't have enough time to make the court understand what the entire memorial talks about. So your crux or the basic factual matrix, how you are going to interpret the law, is supposed to be a part of the summary of arguments. Looking at the summary of arguments, your case should be very, very clear as to whether you all are going to get it dismissed or you all are going to actually argue the matter at hand. The 7th serial number talks about the arguments advanced. This actually is where the summary of arguments are supposed to be interpreted in an elaborative manner. In here, arguments advanced can have case laws which can be added and interpreted according to the moot problem that has been given to you. This is exactly where your pleadings start. Now your pleadings are supposed to be something which you all are going to argue and what you have interpreted, and the same needs to be relevant to the case laws that have been referred. Now there needs to be a bridge between the two. Your pleadings cannot be something that the case laws or the precedents haven't ever dealt with. Now if that is the case, then if the courts haven't dealt with something like that, you all need to come up with at least, let's say, articles, or there's a term called verbatim. Most of the times when an individual approaches the court and it has never been dealt with the court before, what happens is either the judge, the media, or the legal articles they shed light on a particular issue. So when that happens, you can either use the verbatims, or what you can do is the legal articles can be referred even in the arguments advanced set of arguments. Now, the serial number 1 of the issues raised would be your issues, which are, again, as I told you, the issues raised will have sub-issues in a particular head. Now what happens is, if you see the 1.1 serial number, we will explain to the court as to whether you have a right or a locus to appear before that court or not. This is where the maintainability part arises. Now, maintainability is decided on whether you all as individuals or as a group have the limitation or the jurisdiction to approach that particular court. And if yes, you all have the jurisdiction, let's say, then in that case, your case gets approved and it moves to issues framed part. The next subhead would be exactly where your issue, the main issue starts. So the main issue deals with various subheads which can again be distributed between two speakers, and obviously the researcher can help the speakers to move on to those issues in terms of interpreting the questions that have been posed by you all to the posed to you all by the judges. And the last part of it is the most important part, which is the prayers part. This is exactly where you will pray to the court as to what you are asking before the court. Now your ask needs to be very, very relevant to the moot problem. Your ask needs to be very, very relevant to what you all have argued. And if the ask is not something that is relevant, then it becomes difficult for the court to even proceed with the matter. So what happens is, if the prayers is clear for both the parties. Now the prayers might differ for both the parties, obviously, because you all are opposing parties, so prayers might have different set of sections that have been invoked into it, or let's say what two parties are asking for might be different. That is because you all are opposing parties. Now what happens is, when a particular petitioner approaches the court, or let's say when a complainant approaches the court, when civil matters are concerned, the state is representing the opposition. Now when the state is representing the opposition, the government pleader comes into picture when it is a civil matter. And when it is a criminal matter, the APP comes into picture, or the PP comes into picture, which is a public prosecutor. Now all of that needs to be defined by you all in the right sense when the moot proposition is put into your hand. So whether it is a civil problem or a criminal problem, based on that whether the state will intervene in the same matter or not is supposed to be interpreted by you all at the first instance before you even start with the research part of it. So this is how it is, and we can actually scroll through the memorial if you all want to have a look at it. These are the list of abbreviations as I told you. Index of authorities, which is the case laws. These are the books referred and the websites referred to. This is the statement of jurisdiction. You all might actually go through the statement of jurisdiction once only to understand as to how are your fundamental rights or your sections have been infringed, based on which it will be decided whether the matter actually is supposed to sustain in the court of law. This is exactly where it starts. Now we can scroll through a little and maybe come to the statement of facts. These are the statement of facts which are not supposed to be altered by either of the parties. This is supposed to remain the same for both of those parties. The loopholes are supposed to be argued in the issues frame. If you scroll through again, these are the statement of issues. These can again be divided into subheads. If we scroll through, the issues are divided into subheads, which can again be distributed amongst the two speakers who are going to be dealing with the matter. These are the summary of arguments. This is exactly where we are supposed to explain the matter or the issue in brief to the court. So this is the summary of arguments. Arguments advanced is the memo of the petition or the memo of the complaint, wherein you have to explain the issue in detail to the court, which also includes case laws, verbatims, legal articles, and all of this is a part of it. This is the second issue, which is again divided into subheads. So if we move on like that, we reach the prayers part of it. The prayers need to be very, very clear, as I already mentioned, that it needs to be interpreted in the right sense, and whether you have interpreted the problem in the right sense or not will be decided based on the prayers. So the prayers would be different for both the parties, obviously, because you are on opposite parties. Your ask will be different based on the issues that have been framed. And this is where we reach the concluding part of the memorial. This is where it ends, I suppose. Okay. So I earlier mentioned that moot courts generally don't function like the normal courts. So then your question would be very, very valid as to why would people actually, participate in something like a moot court if it is not relevant. Moot courts give you a glimpse of what happens inside the actual courtrooms. Now, if you all ask me, the procedures might be different for the high courts and the lower courts, but what you all do in moot courts is very, very similar to how a high court of any particular state performs. Because in the high court, you don't have the evidence part, you don't have the issues frame part, you directly move on to the filing, you directly move on from research to filing and then arguments of the matter. So it is very, very similar to how a high court performs, and you all get to address and approach the court based on how high courts perform. So it is very similar to that, and which is the reason why moot courts give you a glimpse and bridges the gap between you all who are actually supposed to move on and argue before the courts of law someday. Okay, so as I earlier mentioned, there's no straitjacket formula to research. But when we say that, we at least have the articles that have been valuable. We have the sections that have been infringed. Now, if we go on to search for case laws on free websites, let's say something like Indian Kanun, which is very free for anyone and everyone. Anyone can sign up for Indian Kanun, and if we add on these sections, we get the relevant case laws to it. Now, what happens is we have to figure out whether that particular case law is of our use or it is going in opposition to what we are actually trying to say. This is the only difference between researching for a case law that is relevant to your case and something that is not relevant. That needs to be segregated based on the research. Alright, good question. So what happens is when we add something like a case law into the memorial, you can add the case law, that is a verbatim. The relevant part of whatever is relevant is supposed to be added into the issues frame part. Now when something like this is a part of a compendium, you don't need to annex the entire case law into the compendium. Because it is a moot court. What happens is you add the first page of the case law, the part where the judge has said something or ruled something that is relevant to the proposition, that page is supposed to be annexed, and the last page of the judgment where either the petition, the complaint is dismissed or it is allowed. That part is supposed to be there. That's it. Okay, so when we start with approaching the dais, what happens is there are two teams. A judge is going to judge you all based on the memorials that you've prepared and whatever it is. What happens is you can't directly stand up, approach the court and start with the issues framed. There's a particular way in which you all need to approach the courts. What happens is you can either ask for permission to the court stating that this is council number so and we wish to approach the dais. I'm going to be dealing with issue number so and my co-counsel would be dealing with issue number so and so. So that needs to be segregated and divided between you all as team members, based on which you all need to approach the court, take permission from the court. In case, if let's say you all are arguing before the court, after taking permission, you all have started and moved on with the issues framed, and the judge poses a question to you. Now there comes a point where the judge will probably grill you to an extent where even the judge is not clear about what he's asking, but maybe he needs to understand whether you all have understood the problem or whether you all are clear in your heads or not. In that case, if you know the answer, well and good, you can just go ahead, proceed with it and answer it or address the queries of the court. If not, do not jump into explaining the court in case if you all are not clear. Just tell the court that apologies my lords, the council is not well aware about this situation or this question and wishes to move forward to either the next issue or the next subhead of the issue that the council is dealing with.
In that, can I say sorry or thank you to the bench?
Apologies or oblige are the words that need to be addressed in the court of law. Now that is something that comes with experience, and for that you all will have to participate as much as you all can, and you all can also, this is a very good practice in the Bombay High Court. So let's say the Sessions Court, any individual can go and experience what goes inside the courtroom without having a license, without being a part of the bar. If you all are interns or let's say students, you all can anytime approach the High Court just to understand the legal framework and understand what is the language that is supposed to be used. Now, you all as students are always introduced with legal language in the first year of law school, and that is only because you all get to relate to what actually happens and what is the language that is used inside the courtroom. So that is all it is.
There are many questions which have been going to
Go ahead.
so that we can give the explanations to these students as to why they should appear before this and all.
Absolutely.
The next thing that was coming to my mind is, can I use the word advocate for the petitioner in the moot court?
For the petitioner.
So basically, while approaching for the moot court competitions, there is one thing that has been done by many of the students by mistakenly, that they refer themselves as advocate. So can they refer themselves as an advocate?
You are an advocate for the court, but you need to understand that you all are representing the petitioner. So when you are approaching the court in that sense, you need to understand that you are representing the petitioner as an advocate. Now, professionally speaking, you are a part of the bar, you are an advocate to the bar, but while representing the petitioner and the complainant before the court, you all can approach yourselves as yourself being the petitioners or the complainants. So, I hope you know.
So you can use the word counsel.
Absolutely.
Counsel for the petitioner.
Counsels for the petitioner.
If you could tell us something about the rebuttal round, as to what happens in the rebuttals.
Absolutely. Once when both the parties are done with their arguments and the issues framed in their memorial, and they get done with the 3 or 4 issues that they are supposed to deal with, once that gets done, either the petitioner, the complainant, or the party who is actually approaching the court can ask for permission before the court if they wish to revert to whatever they'll come up with a few things which obviously the complainant or the petitioner is not okay with, or they are not in the right mindset to understand what the opposite party is going to say or has already said. And if the petitioner or the complainant wishes to revert to whatever has been stated in the oral rounds that has taken place, then the petitioners can approach and take permission from the court to seek for a rebuttal. And only when the petitioners seek for a rebuttal, the opposite party, that is the respondent, can take part into the rebuttal round by asking for permission for rebuttals. This is where you get to revert to whatever has been stated in the oral rounds of the arguments.
Last question from my side.
Yes, please.
So that is, while presenting the arguments in the court of law, in the moot courts, where should I focus on?
Honestly speaking, both of it matters, because if the applicability of law is concerned, that is where maintainability comes into picture. And maintainability is the basic part based on which whether your petition sustains the court or not is supposed to be decided. Now, issues framed is a separate part altogether, wherein one need to explain to the court whether, let's say, if a particular issue is maintainable before the court of law, but if you all as arguing counsels aren't clear with what your issues are, you all can't be approaching the court with a confused mindset.
One more last question. If you could tell us something about SLPs, because there are many moot court competitions where they come up with not a PIL or what not read, but they want people to come and file SLP.
Okay, so for example, a particular case law, a particular case comes into picture, and it is SLP is basically a special leave petition, wherein something has already happened in the lower courts, or the High Court has already dealt with it, or the Supreme Court has also dealt with it, but then there needs to be something that has been pointed out again to the court, and the court has missed something very, very important in the due course. That is when SLPs come into picture. It is a special leave petition. What happens is, whatever has taken place on record right from the lower courts till the Supreme Court gets attached as a part of the SLP. So that is where SLP is.
Jurisdiction for SLP?
Supreme Courts is always where SLPs are supposed to be approached with.
Thank you.
I hope.
Question and answer.
Sure.
If anyone has got any questions.
Questions
Thank you. Actually, the question is in the minds of many students at the university. The nowadays, as the AI and ChatGPT, such type of applications are increasing, and it is not a hidden fact that students are going to use these applications for while making this memorials or while presenting the case. So, what will be your suggestion that how we can have a golden bridge combining both like ChatGPT as well as resources which are available in the library or online resources. So, how we can be in that issue?
Okay, this is a very good question, and I can actually elaborate onto this question with an example. And it is really funny for us as advocates to be dealing with websites as ChatGPT, because what happens is I work with a senior. Now, what happens is we either have drafts to prepare, we have arguments to deal with, and a lot of other miscellaneous things that are supposed to be dealt with. Now, when that happens, and you are burdened, we do take up, juniors do end up researching or drafting with the help of ChatGPT. But my suggestion is not to use such apps. Why? I'll tell you. There's a very funny incident wherein the petitioners had approached the High Court recently, and the junior had drafted a petition wherein it was written that the petitioner is saying or mentioned, it has been mentioned in the PIL that the respondent hasn't approached this court with clean hands. Now, when the word clean hands came into the memorial, the ChatGPT referred to Lifebuoy into the memorial because the petitioner hasn't approached the court with clean hands. So, this is a very prime example why people should be referring to ChatGPT or using it. Anything else?
मला असं विचारायचं आहे त्याच्याबरोबर लिस्ट ऑफ डॉक्युमेंट्स वेदर इट इज टू बी अटॅच्ड ऑर अदरवाइज
सर जनरली काय होतं ना, जेव्हा मेमोरियल आपल्याला बनवायला सांगितलं जातं किंवा मूळ प्रॉपोजिशन दिलं जातं, तेव्हा एक सेट ऑफ रूल्स आपल्याला दिले जातात की काय काय आपल्या पेटिशन किंवा कंप्लेंटचा पार्ट असलं पाहिजे. तर त्या सेट ऑफ रूल्स मध्ये असं दिलेलं आहे की तुम्ही लिस्ट ऑफ डॉक्युमेंट्स देऊ शकता. वेल यू ऑल कॅन exhibit the list of documents and you all can add the list of documents into the petition. If not, in the general courts, obviously list of documents is a very compulsory document that is supposed to be attached to any complaint or petition. But when it comes to moot courts, you all have to adhere to the rules that have already been given to you all. So you all need to decide depending on the rules.
whether we can create any documents imaginary documents relating to
Okay, so good question. What happens is, if you all are going to rely on imaginary documents, or let's say you are going to add something imaginary that is not a part of the court records, obviously the opposite party or the court is not going to be aware of whatever you all have thought or imagined. So when it comes to moot courts, I would suggest that you all stick to the problem and not add anything extra imaginary and add it into the memorial. Because what happens is, in the actual courts there is actually a stage which is called the evidence stage, and evidences are actually admitted inside the court of law, based on which it actually becomes a part of the main petition or the complaint that has been pending before the court. But when it comes to moot courts, because you all don't have this stage which is called the evidence stage, and which is why moot courts are only for 2 days, because it is a moot court. Considering that, it is better not to annex or exhibit anything imaginary, because again the courts would not have any guesses as to what you have imagined, and neither will the opposite party will know about your imagination.
okay, thank you.
we don't have any experience or any guidance here, but we do from the professors, of course. But it's a competitive environment over here, so we cannot even approach seniors. So what would be your guidance words here for us now? I would like to correct you a bit here. Let's say if we talk about juniors need to be very, very enthusiastic in respect of whatever they are going to do and participate in. Because if you all don't actually push yourselves and be a part of the process, you all won't be able to understand as to what is supposed to be done. And what is supposed to be taken into consideration is what will happen. The worst case scenario is you will fall 8-7 times and get up the 8th. It is fine. You will learn that way, you will understand things that way. And if there is a senior batch present here, I would like to suggest you all and rather guide you all that you all need to be very, very respectful, and you all need to make your juniors understand that this is something that is going to bridge the gap between you all being students and you all being actually performing before the courts of law. So when that happens, both juniors and seniors have their own set of responsibilities to deal with. Okay, and as for the beginners, what would be the, a mind map to follow to prepare for the competition? The mind map would be very, very simple. As I told you in the real course, there are 5 basic stages that are taken into consideration. But in the Moot Court, there are 3 basic stages. There's research, there's drafting, and there's arguments. So when these 3 stages are taken into consideration, the mind map that is supposed to be followed is you all as a team need to decide who is going to research, who is going to argue, and that needs to be clear between the team. Now when that happens, you will get the moot proposition. You all would research on the moot proposition as a team. But it is the researcher who is actually going to be put to test during the researcher's test. Now does that mean the speakers have no role? Absolutely not, because the speakers will come into picture on the actual day. Again, now you all would question that on the actual day of arguments and the researcher would have nothing to do. But that's not the case. When the speakers are actually arguing before the court of law, the researcher can help the speakers understand the question. In case if the speakers are not able to understand it, the researcher jumps in, helps the speaker understand the question and then get to the arguments part. So everyone needs to be correlating and helping each other when it comes to the entire duration you all are going to be participating in competition. Thank you so much.
Ma'am, I want to ask that which website students should refer for to research.
Okay, so for researching, the free websites I think are Indian Kanun. Otherwise, it is all paid subscriptions, SSC Online, Live Law, and obviously there is Supreme Court has now started a free search engine for advocates and researchers such as us. So Supreme Court website can also be referred to for free.
Indian Kanun is not authenticated website. How you can refer that website for the Moot Court?
I know. Indian Kanun, if you see, you all won't get the correct paragraph numbers as compared to what is actually stated or mentioned in SSC Online or let's say on the Supreme Court website. But then considering the fact that it is a moot court, we can obviously approach Indian Kanun just to get free results out of it and obviously while dealing with it. So for example, if you find a case law on Indian Kanun and if it is a High Court case or a Supreme Court case, we get to know the number of the petition or the complaint that has been filed. Now once we get that number, you all can actually go to the High Court's website wherein the case has actually been filed, or you can approach the Supreme Court's website using the number and you can find the actual judgment from the correct website.
So that you cannot rely on the law sequence such types of
Correct, absolutely.
Yes. But reference from that website is not relevant.
So, let's say for example, if you approach Indian Kanun and you get to know that this is a particular judgment that is going to be in your favor and you need an authenticated copy of the judgment, you can actually figure out which court has the petition or the complaint been filed and you can redirect yourself to the High Court's website, the relevant High Court that the petition has been filed with. Enter the number of the case and find the relevant judgment. Simple as that.
So can we refer Manupatra or AIR?
Absolutely, the best website for Manupatra and AI. Absolutely.
When during Moot competitions, during preliminary rounds, generally time is very limited during that time. Being a muter one, I have to say the statement of facts. Again, issues, if there are 4 issues, 1 and 2 issues. So should I club that issue with argument in advance so that we can able to relevant that what issues we are raising and if what citation we are presenting should get matched. That court held what court is heading in that particular citation should match. Should we can do that?
Absolutely, you all can. What happens is when you are a part of the preliminary round, you being a speaker won't get much of time to actually present your arguments. So you can approach the court stating that if the court is well versed with the facts, you don't need to proceed with the facts of the matter. You can jump onto the issues framed and the arguments at once. And obviously the citations can be a part of it.
But in Moot Court competition, generally muter one has to go with facts of the statement of facts and then issue 1 and issue 2. So we have to do that. Na?
Correct. So you need to actually ask the court first. If the court is well versed with the facts, you don't need to proceed with the facts of the matter.
And the second question is that whether we can able to use that overruled judgment of Supreme Court itself given by single bench or given by double bench in Moot Court problem.
No, sir, overruled judgments can never be referred because there's a reason why they are overruled. And once they are overruled, there's something that is actually presiding that judgment. So something that is presiding or overruling that judgment is supposed to be referred and not the overruled judgment itself.
But being a petitioner, if I am using that judgment, overruled judgment, and respondent is that having knowledge of that judgment also, then also we can't use that.
It might happen that the opposition isn't aware about the judgment which is overruled, but the courts are always aware, sir. So it is better not to refer to judgments which are
In Moot
overruled.
Court also we should not refer it.
Not at all, not at all.
Okay. Thank you.
I hope I've addressed the queries well.
How many types of benches are available in Supreme Court or High Court? Benches of judges.
Benches are either, if a single judge is sitting, obviously it is a single judge. If 2 judges are there, obviously it is a division bench. And then it goes on to 5 judges or 7 judges. Those are larger benches that deal with a matter which is of higher importance in terms of fundamental rights.
Thank you, ma'am, for patiently answering all the questions and clearing our doubts. We extend our heartfelt gratitude to you, ma'am, for taking out your valuable time to guide us through this Moot session. Your insightful lecture, the techniques you shared, and the detailed explanation of the Moot Court have truly enriched our understanding. The clarity with which you deliver every point has boosted our confidence. On behalf of everyone present over here, I sincerely thank you, ma'am, for your guidance, encouragement, and support. Now I would like to call our principal, Dr. Sanvi Deshmukh, ma'am, to guide us on this same.
Good afternoon, everyone.
Good afternoon, ma'am.
So, first of all, I would like to take this opportunity to thank Sakshi ma'am. So, I would like to tell you all that Sakshi has been a student of me from ES College of Law. She's always taken part in various debate competitions, elocution, moot court and all, and she has always been a pride to the college while winning all those competitions at national level, state level, university level. One of her best achievement was at Nani Palkhiwala elocution competition wherein she's won the first prize. So while talking about Sakshi, I always say that Murti Lahan Kirti Mahan. While looking at her first, people usually feel that अच्छा ही छोटी सी मुलगी आहे ही काय बोलणार. But once she starts speaking, then people are impressed with the way she speaks. So really appreciable here. Now, while calling Sakshi here for this moot court session, is to inspire you all as to why we have taken part in the LLB course. It so happens in our family that as and when debating with someone, आपण घरातल्या घरात भांडतो. मुद्दा said is absolutely right, and then somebody from a family usually says, "तू वकील बन." That is a profession that you want. So basically, we are here to prove the fact. Why they say that advocates are known for proving the facts of the client. They are not there to prove what is right, what is wrong. They are there to prove as to why did that happen, what is the main reason behind it. And for this, at an initial stage, for law students, we have moot court competitions, wherein a proposition is being shared with you all. Proposition is a single facts. You'll receive a case where they'll give you all the facts stating that so and so has come, so and so has happened and all. So the first thing that we need to do is read that proposition for 4 to 5 times. Because in that proposition, most of the things are irrelevant. But most of the things that they have given you is to pick up the points from the same, the loopholes in it. So while we will give a 1-page proposition, it is expected from you to make at least 20 pages memorial from the petitioner's side and then from the respondent's side. So how are we going to expand that for 20 pages? For that, at an initial stage, they have given you these issues. They have asked you that first you do one thing, understand the locus standi jurisdiction, whether that particular court has got the jurisdiction or no. So the first question that they raise is, why have you come before us? Why not any other court? Usually the first mistake that every student does is they go to Supreme Court. आम्ही खाली High Court ला मानतच नाही. So then the Supreme Court asks that why have you come to Supreme Court? You could have been to High Court as well. So then many of you might have got a question in your mind that High Court जाणार की Supreme Court जाणार ते त्यांनी लिहिलेलंच असेल. It is not like that. So while we make a memorial, in that the first page we write, that is title page. Wherein in that title, you write the title. You have to point out whether it is a writ petition, or it is a PIL, or it is an appeal, or SLP, what it is. So make sure where you are approaching. Because the first thing that you need to prove is maintainability. That this particular court have got the right to decide the judgment. Let's say, can I file a marriage petition case before Sessions Court? Which cases can be filed before Sessions Court?
Criminal.
Only criminal cases. District Court? Only civil cases. So while approaching before the court, you have to make sure that which court are we writing at the top. While going for the appeal, if it is said in the court, in the case, that appeal is already been decided, the matter has already been referred to the appeal and appeal is been rejected, then what we can do? We can file special leave petition. Where to file a writ and where to file a PIL. Let me tell you all, PIL is a writ only. PIL is also a writ. The difference between PIL and writ is writ can be filed for the violation of the fundamental rights of the individuals. A person can file a writ for the violation of his own rights. While a person can file the PIL for the violation of the rights of the people at large.
Yes.
So that is where we file PIL. In PIL, we have to prove a fact that I do not have a direct interest in the matter. I am filing this for the interest of the people at large. So, why I am explaining this all again is because while going through the Moot Court, it is must to understand what is the case all about. It is not just about the issues. Because rest of the case that has been very well explained that how to write, how to draft and all. Then why just listen. While I write appeal, can I write the name of the parties as petitioner and respondent?
No.
No. Then as and when I am filing an appeal, it has to be appellate. So we have to be very careful as to what are the names which have been given to the parties. Now coming to final years, next week you all are having your Moot Court competition. Not a competition, it is an exam. So for this, what is expected from you people? First of all, to understand the case. Whether you people have understood what is the case, what are the issues involved in it, and what are the sections to be made applicable for the same. So you have to divide amongst yourself. Here, we are not going to fight against each other. Do not take it personally, stating that नहीं, हम लोगों को जीतना है. We are not going to give marks on the basis of who have won the case and who lost the case. We are going to give marks on the basis of your understanding, whether you have understood the matter, whether you have understood that act, whether you have made it applicable, whether you are like, and whether you people are ready to go before the court of law. Many times it also happens that in the group of 4, how many people are there in one group? 4 or 6? 4 to 6 I would say. So as of now, final year people those who are going there. So in that many times it so happens that we are going there as a group. 2 people are well prepared and rest of the people are not prepared. Because they have their other priorities, they are not fully prepared, so they are not presenting well. So the one who is more prepared, now they will take the pressure. Madam, आपने छान करके तुमको बोला तो नहीं, त्याच्यामुळे आमचे मार्क कट होतील का? नाही. Though it is a group activity, it is expected from you that you people should sit, you people should discuss the activities together, but it is not that because your group member has not presented well, we will deduct your marks. So you have to also focus on what presentations are we giving. Okay. Many a time it also happens that XYZ person is not prepared, so what I will do is, मला तर टेन्शन येत आहे, I am not prepared, I don't know what to say. Do one thing, तूच सगळं बोल, मी फक्त प्रेयर वाचतो. So, again, the one who will just come, just read the page will not get marks. Why I am saying this, why I am repeating this? Because I don't want any one of you to take a pressure because of your teammate. It is expected that please do not come and read your memorial. Those who are not prepared, what they do is, आम्ही जाऊ, आम्ही तिथे पेज ओपन करू, पेज उभं राहू आणि आम्ही रीड करू. You are supposed to do that. Okay? As I mentioned about prayer, can I add on the prayer at the last moment, which is not written in the memory? Last moment मला वाटलं की अरे हाँ, this can also be the prayer. Can I add on that prayer? Yes, no.
No idea.
So basically, the rule of the code is such that once you give something in writing, you are not supposed to alter those things. You cannot add those things. That is why there is one line that we write at the prayer is whatever the code may give fit. So any other thing, so that there is a scope that you may request the code at the last moment. Yes? Usually it so happens that the day of the argument, when you argue the matter, when you present the matter, त्या दिवशी मला क्लिक होतं की अरे हा हे सुद्धा बोलू शकलो असतो आपण. Then you can add that in that particular line, then you can request the code. While citing the prayer, it is expected that you should be, the team members should all rise and they all should stand. While coming before the bench, you should go down before the bench. Many of you have been to the courts. Court visits have happened. Have you observed the fact that all the advocates, those who are entering the courtrooms, they are going down before the court was, while leaving the courtroom also they are doing the same.
Yes.
So that means we are showing a respect to the court. Very same way it is expected that while coming before the bench, we are supposed to go down before the bench and while leaving also. The council seeks permission. लक्षात ठेवा, लिहून ठेवा. What are those three words? The council seeks permission. The council seeks permission to present the memorial before the court. The council seeks permission to present the evidences, compendium, whatsoever it is. So whatever that you do, you have to say that the council. Then, as I said, rebuttal. What is rebuttal? Anyone? That's a new word for the people those who have not done Moot Court. Anyone? Rebuttal? Like cross question. So basically, rebuttal means at the end of the Moot Court presentations. Moot Court presentations are over. Now, what something is being presented by the petitioner, which respondent does not agree. की तुम्ही लिहून देणार नाही, काही लिहून दिलेलं नव्हतं, त्याच्यावर आम्ही हे केलं, and now there is something that you have added. Or vice versa, respondent has said something and now petitioner feels that अरे यांनी हे present केलं, हे तर माझं बोलायचं राहूनच गेलं. I can say this. So there, that is rebuttal, that you can seek the court, like you can seek the permission from the court to present a rebuttal. For rebuttal, they do not give you more than 2 minutes. Am I right, ma'am? Not more than 2 minutes. It should be precise. But there is a chance wherein if something is missed out and you feel that the respondent has presented this, I have not done that. You can present that. You cannot add on things. Rebuttal is only to give answer to a